What's up, everybody? We're back with the newest and latest ex parte hearing in the YSL trial, a motion for mistrial. They're refiling everything to see what this new judge is going to do, but we had to look into what happened at yet another secret hearing with Judge Glanville. I believe it happened before the prior hearing. We don't know. We haven't read it yet. You guys sent it to us. My dad's going to come on. We're going to break it down now. Make sure you guys hit the like button before we start. All right. What's up, Dad? Let's
How you doing?
take a look here. I am doing well. I'm
Good.
going to zoom in on it a little bit so we can all see it. It's the first time we're looking at this. Neither of us have read it yet. Been doing a bunch of other things. My dad is out of town, but we're going to take a look and we're going to break it down and hopefully get a bunch of your questions answered. This is the supplement to Deamonte Kendrick's motion for mistrial. So one of the things this new judge is doing is telling the lawyers to refile a bunch of motions so she can make her rulings, look into what's there, figure out what's going on, catch up. I don't expect any of these motions to be granted. Nobody's gotten bond yet, but maybe something will change that. And then everything exploded in my DMs about the ex parte hearing, another ex parte hearing. So we're going to get to the entire transcript here. It's attached to this motion, but let's read the motion first, or the supplement, I should say. Outside agitator is a term that delegitimizes internet dissent against the status quo. So anyone who speaks up against the status quo, whatever that is by definition an outsider. Quoting Professor Dylan Penningroth. Judge Glanville making outrageous allegations against members of the defense team in the present case, but I think it does in some way outside agitators and everybody else who I think are trying to influence. So he's quoting what happened in this ex parte hearing. The third ground argued in Kendrick's motion for mistrial is that Kendrick's due process rights were violated relating to a 14th Amendment due process violation relating in part to Chief Judge Glanville's wrongly coercing Copeland to testify. So it's all around the similar factual scenario that we had the first time. Further evidence of the state and Judge Glanville's violation of Kendrick's due process rights has just come to light. Yesterday after court, Kendrick received a rough transcript, which is attached as Exhibit A, of an additional secret ex parte meeting with Judge Glanville held on Friday, June 7, 2024. The rough transcript was helpfully provided by this court to defense counsel. A reading of the rough transcript highlights that which has been obvious to all observers except for Kendrick's counsel for the past 19 months. Judge Glanville has been willfully biased and acting as a member of the prosecution team since the inception of this case. Kendrick's counsel takes no pleasure in alerting this honorable court to this situation, but the client obligations require it. Due process requires a fair trial. Before we keep going, let me scroll here. Yeah, this is Weinstein, which first off, this is the guy that shouted us out on Twitter. So what's up, Attorney Weinstein?
He's also the one that filed the first recusal motion.
But what I'll say is something that I've noticed throughout this case is he has not been quick to jump the gun on calling Glanville biased and saying he's ruined this case. He has tried to, as we would with most of the judges we practice in front of, lift the judge up, give the judge the benefit of the doubt, hope the judge is doing the honorable thing. It sounds like he's finally, this is kind of the straw that broke the camel's back with him. That's kind of the vibe I'm getting here in the first page and a half of this motion. I'm sure he will correct us on Twitter if we're wrong. It is not a fair trial when in an ex parte meeting, Glanville, Love, Hilton gossip like yentas over 13 pages of transcript about attorney Shart, Melnick, and Steele. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton assassinate the character of attorney Melnick and attack his integrity, alleging that he is not acting in the best interest of his client, Copeland. It is not a fair trial when in an ex parte meeting, Glanville, Love, and Hilton attack attorney Bumpus for allegedly hugging Kendrick and stating that she is incapable of representing Copeland. It is not a fair trial when in an ex parte meeting, Love lies to Glanville about an email she received from attorney Melnick. These are serious allegations that I don't think this guy's he's a very seasoned lawyer. I don't think he's going to do this flippantly. It is not a fair trial.
I love his phrase, gossip like yentas. That was a great phrase.
It is not a fair trial when in an ex parte meeting, Glanville starts talking about outside agitators, stating my comments today were predicated on there's a lot of stuff going on in the background, but it shouldn't have to do with anything with you all's case. It really shouldn't, but I think it does in some way. Outside agitators. It is not a fair trial when in an ex parte meeting, Glanville and Love have the following outrageous conversation. Outrageous. Court. But I think it does in some way outside agitators. Ms. Love, that too. Court. And everybody else who I think are trying to influence. Ms. Love, that is absolutely happening. It is not a fair trial when Glanville, Love, and Hilton have this further discussion. There's a lot going on. There is a presence. Yes, that is all I'll say. The court. I mean, but I see it from just being in the courtroom and tracking. That's interesting. It's like they're saying stuff, but not saying it. How many violations of Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice? This case is like an old house that the present honorable judge is tasked with renovating. Every time a piece of pasted up wallpaper is removed, more rot is found hidden underneath. No Herculean effort by the present court can fix the due process violations of the last judge. This house must be torn down. A mistrial should be declared and retrial barred due to the prosecutorial and judicial misconduct that has goaded Kendrick into the present motion. Wherefore, Kendrick respectfully continues his request that this honorable court declare a mistrial based on at least due process violations of Kendrick's constitutional rights under the federal constitution and the constitution of the state of Georgia. What are your first impressions of the motion?
Well, first impressions of the motion are there's a lot of questions that I'd have to ask. These, if we had a hearing, I'd really have to ask a lot of questions because, what he's talking about when he goes through the quotes from the transcript, to me, it's not clear what they're talking about.
I agree.
They're either talking in code. They're the only ones who know what they're talking about, which is obviously not good. But there's something going on, but there's too many questions unanswered. If I were this judge, I'd have a hearing. I'd get this all sorted out, but I think I would deny the motion because I think I would say, look, you got what you wanted. The judge is gone. I'm a new judge. I'll go through all the transcripts, which I think we've heard she's doing. I'll go through all the transcripts, and I'll find out whether there has been a for sure due process violation that warrants a mistrial with prejudice. The other thing is the odds of getting a mistrial with prejudice are slim and none as well. So the best they can hope for is a mistrial, but this deserves a hearing because I don't understand what they're talking about.
I don't get what they're talking about either. It doesn't sound good. And I mean, the due process stuff the ex parte stuff should never happen like this. It shouldn't be an opportunity for the judge and the prosecutors to gossip about the case, talk about the defense lawyers, talk about the defendants, talk about the witness, discuss the stuff going on outside. I mean, that's all this is. That's the only context I get from this motion, and it is horrible.
But the other thing is kind of weird. They had a court reporter there taking all this down. Which, I mean, really, frankly, if they want to do stuff like this, there's no reason to have a court reporter there.
It's like they just think they're above it. They're above the law. They can do whatever they want.
And the impression I get from this motion is that this new judge is cleaning house. She's going through everything she can find and turning it over to the defense and letting the chips fall where they may. I think she knows she's not going to do a mistrial with prejudice, but I think the analogy is correct. It's like an old house where you're trying to renovate it, and every time she pulls back some wallpaper, I think that is really a good analogy, but it doesn't mean that you can't renovate the house. It just means it's a lot more trouble than you thought. Yeah.
All right, let's get to the transcript here. 2:45 p.m. Ms. Love, Judge, the reason that I specifically wanted to talk with you is that I have concern about the representation being made of the representation of Mr. Copeland. I am concerned, and I am sort of not. I wanted to just bring it to the court's attention. Mr. Melnick has not conveyed to either Ms. Hilton, myself, or any other member of the state any legitimate concern that he has regarding Kenneth Copeland testifying. What we have seen is physical interactions with persons besides Mr. Copeland that would indicate that Mr. Copeland is not Mr. Melnick's primary priority. Again, that's directly commenting about an attorney-client relationship, another defense attorney to the judge so they can gossip about it. What we do know is that the fact that he's willing and wanting to leave, number one, he left twice after the court ordered him to speak with his client, and it would seem his actions convey that it is not Mr. Copeland's best interest that is his priority. Ms. Hilton was out speaking to Mr. Copeland, and Mr. Copeland requested at the time that I announced that Ms. Hilton was calling Mr. Copeland. What I did not know is that she was trying to tell you to give us a minute because Mr. Copeland was feverishly, and I will let her speak as to how that went down, feverishly trying to get her in there to convey to her something that Mr. Melnick had just said to him that did not come from any of us. First off, she should say, you're waiving your attorney-client privilege. Like, you should think about this stuff if you're a lawyer. The court said, what was that, Ms. Hilton?
Remember from the other hearing, she claimed she didn't even know that Melnick was representing Copeland. She had that doubt, which was ridiculous because it's on the record, filed in the court file, that he represents Copeland. But she, first off, had this doubt, and we know that doubt's ridiculous. And this makes it even more ridiculous because this happened at 12:45. So she is saying that she knows Melnick represents Copeland. I mean,
right. Without a doubt. So when I went into the room, Melnick either came in or came outside. And what Mr. Copeland said, that I think that he wanted to get some autonomy. I want to think to you. He's like, I've already talked to you, but I want to talk to her. And Mr. Melnick kept blocking him being able to talk to me. Shocker.
It's his job.
Literally. So eventually I was like, well, clearly you want to talk to him, so I'll step out and you can come in. Yeah, she's acting offended or surprised by that. Mr. Melnick spoke to him, and I think he was trying to eat up time because he knew that you were coming out. So by the time I got back in there and he started to talk, that is when everyone said, come on, the judge is waiting. And that's when he stormed in angry. These conversations are appropriate if she wants to have these with the state attorney, the person she works for in her office. This is not an appropriate conversation with a judge.
This transcript to me is also shocking because we had these hearings. It went to another judge for recusal. We had all the arguments. We had all these documents filed. We had all these transcripts filed, and no one knew, and no one said, including Granville or Love or Hilton, no one said that this hearing or this ex parte hearing took place. No one said this transcript exists.
I don't know who knew about this one. I have no idea.
Well, we got the order, and the order does not say anything about another transcript. We got the order of the recusal order. The only thing that judge reviewed was the ex parte hearing transcript. No one else knew about this except for Granville and the prosecutors.
I think he was trying to convey some concerns he had, and so I was trying to have that conversation because Mr. Copeland and I have been having really good conversations since Friday, very, very good conversations. The prosecutor saying that just not even about the facts of the case, but just life experiences. So I think I was building a rapport with him such that he thought I lied to him. So I was trying to explain to him. And by that, she means today. What?
She was grooming him. That's what she was doing. She was getting his rapport, getting his confidence so that she could get between him and his lawyer.
Today, about what was going to happen because of what someone conveyed to him. Hilton, we believe that something was being conveyed. What happened is, as Mr. Copeland was walking back in the courtroom, Mr. Melnick and Julie would have to, Miss Lansicote, would have to confirm this, but he said, they are going to hammer you. And that made me ask Miss Love, did you say something about hammering him? And I don't know who. Nobody did. Again, this is something that should be coming out in front of the judge where Melnick should be able to be representing himself and why he said it and what he said, not just one side. This is what happens in other countries, not in America. It's not supposed to happen. Nobody did. That doesn't make sense. The judge says, it doesn't make sense you would say that to him. Without hearing the other side, without hearing from any defense attorneys, the judge just takes the prosecutor's side and is like, yeah, that makes sense. Never said that to court. But anyways, okay. Clearly they're chummy, right? I mean, clearly they're chummy back there. So whatever that communication was, that's when he stormed in and got angry. And the result I got was that he gave when we started. So at this point, I'm very concerned. Miss Love, he, meaning Mr. Copeland, stormed in and got angry. Miss Hilton, the timing of everything is very ironic. We laid it out on the record earlier about what happened. And I don't believe that Mr. Copeland's best interest is being served at this moment, given that, Mr. Melnick was willing to take a vacation and let him languish in jail. And that is not, we have communicated that we never wanted Mr. Copeland to go to jail. We don't want him in custody. We don't want any of that to occur. And so, and Ms. Love said, and Mr. Melnick, he had a prepaid vacation to Alaska or something. It's not like he went to Orlando. Was not spoken. He has not relayed. What we did get during the break was an email from Mr. Melnick. I don't know if he He had to have been blind copying someone else. The only two people I could see on the email were Miss Hilton and myself, but he referred to me in the third person and said, these are the communications between myself and Miss Love. So I asked Mr. Melnick, whose interests are you concerned about, your clients or Mr. Steele's and Mr. Schart's? Because prior to, and this is not the first time Mr. Copeland has said he doesn't represent me. This is not the first time Mr. Melnick has. And let me be clear, when he spoke of what was happening before him representing Mr. Copeland and he told me that he didn't represent Mr. Copeland. He told me, the court said, Mr. Melnick told you? It's like so confusing what she's saying. Love says, yes, Mr. Melnick told me previously that he wasn't representing him. The court says, you would not speak to an unrepresented party. I mean, I know you know enough of the rules to know that if you thought or intimated that somebody was represented by counsel, you would go ahead and let them contact that lawyer. Right? Or Mr. Copeland would have said, because I don't know as a witness, because he's not charged, if he would have the right to. So she's like, I don't know the rules. I don't know if I have to do that. Miss Love's like, right, because he's not charged. I don't think you have to because there's no pending charges. But if he told you I got a lawyer, I don't want to talk to you, well, then we would have left. Talk about muddying the waters on purpose. Because people counsel that they have under retainer or something else, or they say, hey, I got a lawyer that I use for everything. I want to talk to him. I don't know. I'm not comfortable talking to you unless my lawyer is present. So they're back there kind of discussing it back and forth without a defense attorney, without Melnick. We have done that with a number of our witnesses. Oh, great. This is just the way they do it down there. This would have been no different. Exactly. We would have. I'm sorry. I don't mean to cut you off. No. Go ahead. That was it. Miss Love, we actually communicate, especially when either they are incarcerated or subject to their sentence revoked as a result of their testimony because they pled guilty here. We only reach out to them through their attorneys because we want the attorney to speak to them. And for that to be because that's the best way, in our opinion, to get a rapport that's ethical, that elicits truthful testimony. So in this particular instance, there was not that, number one, there was not that communication made by Mr. Copeland that there was ever a need for that. And two, there was not a need for us to be concerned about it because he doesn't have charges. Ms. Hilton explained to him at length. By the way, whenever somebody has an attorney for the thing that you're talking to them to, you as an attorney can't talk to them. It's not just criminal cases where there are charges pending. That's not a thing. Like in civil cases, I can't go talk to the defendant himself. He's represented by counsel. If I know that, I got to talk to counsel, especially if it's with what we're doing and I know about that. That's just an ethical obligation we have. It's different than somebody's constitutional right to counsel. Hilton explained whatever happened he did in 2015, which is all we're going to talk about. The statute of limitations has run. He didn't do the M. We don't know that. We know that. I mean, so I don't want to get into the facts of anything. What I'm trying to get at is the fact that Mr. Copeland, I believe Mr. Melnick has inserted himself in a way that jeopardizes the best interest of our witness. I believe that in conveying to the court that Ms. Bumpus is going to stand in his stead. Ms. Bumpus what is the word I'm looking for? The sheriff had to speak to her because she was in the courtroom trying to hug Jeffrey Williams. Ms. Hilton, no, she hugged Deamonte Kendrick. I'm sorry. In fact, she hugged Deamonte Kendrick and hugged Mr. Williams, and that's how Captain Kendall saw her, and Captain Kendall had her taken out. Ms. Love, she expressed dismay and concern in challenging her right to go interact in that manner with the defendants. So our concern is that what are your comments about that Attorney Bumpus may have hugged some of the other defendants?
Well, again, this is all ex parte. This is outrageous stuff. No one's there to argue about it. No one's there to object to what she's saying. She can say she gave him a kiss on the lips for all we know. It doesn't matter. It just doesn't matter.
I don't think it looks great.
All she's doing is prejudicing the judge. That's all she's doing. She's taking advantage of a situation where no one can challenge what she says. And she has the judge's ear one-on-one, and she can say whatever she wants, and no one's there to question it or challenge it.
So, number one, maybe not great that this attorney is hugging the other defendants, but outside the presence of the jury does not affect the case at all, number one. Number two, Copeland isn't saying, I want to fire her because of this conflict or this issue. So, again, a nothing burger, in my opinion. So our concern is that it is not Mr. Copeland's best interest that they're being represented, and not only is that the case with respect to Copeland, who we have no interest in prosecuting, but there's tampering of sorts going on in this person inserting himself where Mr. Copeland has been reaching out to speak to Ms. Hilton. So now she's accusing people of tampering charges in front of the judge. How is this appropriate? Mr. Copeland's been reaching out to speak to Ms. Hilton, and that communication is being blocked by someone Mr. Copeland can't or didn't reach out to. Wow. You notice no one said, Mr. Copeland called me. He never said, when we put on the record, when Ms. Hilton said, the way I understand it, Mr. Melnick reached out to Mr. Copeland because the first time we heard an assertion like, oh, he's going to plead the fifth, is when Mr. Melnick sent an email to Ms. Hilton and myself and had copied on it Mr. Steele and Mr. Sharp last night. Well, that's normal for the lawyer to say, my client's going to plead the fifth, if you have a lawyer. Why would he have done that given, and that's the state's concern. That's the point. But here is the challenge. This is the court. The challenge is you have privileged communications, and unless you've got him being the client, disclosing to a third party that wouldn't be subject to the privilege, that is the only way you're going to. So this is a judge helping them figure out how to get certain things in and how to win certain arguments, right?
I'm baffled by this hearing, although this transcript fills in some of the blanks of the other transcript. Mm-hmm. We would say, how did this come out of nowhere that he had this hearing? How did this hearing start out with Miss Love being the first person to really speak at that ex parte hearing that we have read before? Now we understand, because this gives the background to what's going on. And this really makes it make sense now as to what Love and the judge and Hilton were doing prior to and outside of the presence of Copeland and outside of the presence of that last ex parte hearing. This tells you something was in fact, because we suspected that. Remember, we said that you don't just start off like this. What was the emergency? Was there ever a hearing as to what the emergency was? The judge never got into it. The reason the judge never got into it is because he heard all this. And so his mind was all done and closed by the time that hearing opened, that last ex parte hearing opened.
Yeah, he had all this context.
Right.
This is Ms. Love. I don't agree with that at all. I don't disagree with that at all. But if Mr. Melnick, and the thing that got me the most is Mr. Melnick is not looking at Mr. Copeland saying, Mr. Copeland, I want you to stay out of jail and I will be here with you. So basically she thinks Melnick should just tell his client, do whatever the state wants you to do. But it's not how it works. And if they ask you anything that touches upon something that you and I talked about, I will stand up and assert your right. He didn't do that. What he did was he looked over the two people and said, I did what I could, and shrugged his shoulders and held up his palms and his hands like this to say, I tried. Again, accusing him of working against his client, being unethical, tampering, working with other criminal defendants in the courtroom. Those are the accusations she's throwing around in front of a judge where the attorney cannot defend himself. There is no reason he would be looking to the right to counsel for that, like I tried after Mr. Copeland said he was going to testify. That doesn't make sense. Well, there's a lot of innuendo, the court says, that they have asserted themselves, they being some of the defense counsel, have inserted themselves in this particular process. That's the judge. He's biased against the defense lawyers. If he is saying that, he is now biased against the defense lawyers. He has not made those findings. They have not had any hearings to find that the defense lawyers have done anything wrong, but the judge is saying he thinks they did do something wrong.
Well,
without any due process.
He's accused him of a crime. Basically, he's accused him of obstructing justice because he's saying, they obstructed justice. They obstructed a witness testifying before me in a trial. And he should have held him in contempt, referred it to the state attorney's office for a criminal investigation, all sorts of things he can do if he really thought this was happening.
My concern is Mr. Melnick's insertion of himself. What are you asking me to do? The court says, what are you asking me to do? And what do you think I can do? Ms. Love. That is the exercise. That is the homework for tonight. I want to let the court know that is what we're looking into right now because there is a remedy, because I have faith in our law. I love this thing. I know there is a remedy because this can never have been the first time this happened. It has been addressed. I just have to find it. But I didn't want to be looking for something and not let the court know what I'm looking for so that you're not caught off guard Monday morning or Saturday night or Saturday afternoon when we find it and send it to you. The judge. Okay. So basically, hey, judge, let's all go work together and try to find, a way to do this. So thank you for allowing us to the audience with this court. I just wanted to make certain that we did it properly. And we had everything on the record. It is our witness. We have conveyed to him that he is shielded from prosecution for anything that he talks about on the stand and any use of that. And the thing is that we won't ask him, but this is what he said. Y'all might not, but they might ask me about some things that I have to assert my right on. And that would be a question by question basis. What he is being influenced to do, we believe, by Mr. Melnick is, and it's through Mr. Melnick because, as you saw, Kenneth Copeland said, I will testify. Mr. Melnick, even after that, said he's asserting his fifth. I'm going to talk to him. Logically, one would think that as long as Mr. Melnick's concerned about Mr. Copeland's freedom, again, she's saying he should only be a concerned with one thing, and that's his freedom. Well, sometimes that's not the case. A lot of times that's not the case. Legal freedom and his exposure, as long as those were addressed, Mr. Melnick should be saying, again, just telling defense attorneys what they should be doing. I wonder if she's ever been a defense attorney. Mr. Melnick should be saying, I'm here with you. If there is something that I know will put you in jeopardy, I will stand up and stop you. But right now, I would rather you stay out of jail. He is telling him that. She just doesn't like what he's telling him could put him in jeopardy, right? She's saying he should stand up and say, plead the fifth. It's like, well, maybe that's what he's doing, just not in the same issues that you think could put him in jeopardy. Instead, you get Copeland.
Maybe she doesn't know. Maybe she doesn't know everything about him either. Maybe she doesn't know the things his lawyer knows.
Duh.
All she's doing basically, it's just typical. She's a career prosecutor, and some career prosecutors just view every criminal defense lawyer as being a criminal because they're a conspirator with their clients and they obstruct justice.
Right.
Wouldn't the world be wonderful if there were no criminal defense lawyers, only prosecutors? You get arrested, you get tried in court, you have no lawyer. The only lawyer is the prosecutor. You get convicted and you get sent to prison. Wouldn't the world be smoother then? And that's her attitude.
That's what a lot of people think, unfortunately, until it happens to somebody they know. Instead, you get Copeland. You see his body language. He gets there in court. He's smiling, making a show of being taken into custody after this. And the man don't want to be in jail. He said it. Didn't he say he don't want to be in jail? That's his biggest fear. That's his biggest fear. Now he's in jail after Melnick asserted himself in the process. Every lawyer then asserts himself in the process. If they're accusing a defense lawyer of asserting himself in the process and tampering and obstructing justice in this way, then every one of us has done it in every case we've ever had. It's so stupid. So we have to go figure it out. I'm not just laying it in your lap saying, go fix this. Well, that's nice of her to not tell the judge to go fix it. I'm just bringing this to the court's attention. This is a grave concern. Ms. Hilton, she's about to lose her mind because her biggest concern is that Melnick is actively harming a human being, and that's what she's maddest about. I'm mad because it's stopping our trial and it's wrong, and that is not how the law is supposed to work. So we have two big, old, grave concerns. What are that we are working on to remedy right now? The court. Okay. Well, like I said, I think that you brought your concerns to me. Without more, I don't know what else I kind of do in terms of that. Today, we're predicated on there's a lot of stuff that's going on in the background, and it shouldn't have to do with anything with you all's case. It really shouldn't, but I think it does in some way. Outside agitators. That's what the judge says. That too. And everybody else who I think are trying to influence. So who's he accusing of trying to influence? Other lawyers, other criminal defendants. Who are the outside agitators? That is absolutely happening. There's a lot going on. There is a presence. Yes, that's all I'll say. And then the court. But I see it from just being in the courtroom and tracking. But okay, if you find anything, we'll see where Monday leads us. And like I said, since we now know he's going to potentially invoke, we'll see what his pleasure is. And as Love said, just an idea of someone sitting in jail throughout this trial. But if that's what he's being counseled to do, and that's what he does, that's just wrong. It's wrong because a member of the bar is, in my mind, creating that circumstance. He's going to do what the person he trusts to have his best interest at heart tells him to do. And that person, he doesn't have to tell us what he's concerned about and can just sit in there. And when he sees the train coming, stand up and say, stop. But he's got a vacation to go on, so he can't be here. So Ms. Bumpus is going to be here. Ms. Bumpus, hugging Mr. Kendrick and Mr. Williams, is going to be here representing the interest of Kenneth Copeland, who is supposed to testify against Mr. Kendrick and Mr. Williams. They assume he's going to testify against them. That is where we are. That doesn't pass the smell test. And apparently that's all you need to get in front of this judge and argue and basically help him make up his mind. Judge says, all right, okay, thank you. And the certificate of service.
You know
End
what's, you know what
scene,
else?
basically.
You know what else is funny is if you remember what Glanville said was the state asked for an emergency hearing. He never said that there was an ex parte hearing. He never said there is a transcript of that request. He never said anything like that. This all took place. And then what happened was they went and did their research. And then there was another ex parte communication, which I'm sure happened, where they told the judge, because when this ended, they had not asked for a hearing. They had not asked for an ex parte hearing with Bumpus. So somewhere between here and when they had that hearing, there was another communication with Judge Glanville where they said, we need an emergency hearing. We've done the research. We got him. Let's have that hearing and let's take care of it. So there's something else that happened between these two hearings.
I honestly just can't. This one almost feels worse, like so chummy, so on the same page, so working together to make this happen, so inappropriate. Like the other one seemed a little bit more professional, especially by the court. Maybe it's because the bailiff was there and Bumpus was there with her client. This felt like a bunch of friends, buddies, sitting around figuring out how they're going to fix this problem they all have together. And that's not, they're not on the same team. The prosecutor and the judge are not on the same team. That's like a ref and the opposing team. They're not
the judge never questioned her assertions that Melnick was not working for his client. The judge never once said that.
Never said, stop, Miss Love, stop. We need to hear from Melnick. I'm not going to take any accusations here in my courtroom or in my chambers. Just relax on that. If you have a problem I can help you with, let me know. But don't disparage other lawyers in my chambers. Didn't say that once like a reasonable and ethical judge would. Right. That's what you would expect to hear and what you'd want to hear as a lawyer ourselves.
And this guy is no rookie. He was the chief judge, been around a long time. I mean, I can't imagine what his history must be if he didn't stop this and say, Miss Love, stop. I'm not going to hear this. You need an emergency hearing. Fine. I will give you an emergency hearing, but I'm not going to sit here and let you do all this stuff with nobody else here in the room. I can't be the first time he's done it. I mean, I can't imagine it's the first time this has ever happened. Not to this.
This is bad. I don't think it's going to get a mistrial granted with prejudice, but this is bad. And this is going to be a major appellate issue. But have they solved the issue by getting rid of that judge and putting a different judge on who's not biased against these defense lawyers, right? And that's kind of the point of what we're talking about here.
Right. And that is. And she, again, I don't think she's going to say that the trial really is a manifest injustice. I think she's going to say that, all these rulings, let's just keep on with the trial. If there's any issues you think I need to correct from the past, just bring it to my attention, and we'll deal with it. I think that's what she's going to do.
Yeah, I don't disagree. So anything else from this ex parte hearing?
No, but like you, this is a shocker, but it's also a shocker because it was never revealed. When the lawyers were arguing, you didn't hear anything about this. And this transcript, pops up. And when that judge, I forget her name, but the judge that considered the recusal, she didn't mention anything about another transcript.
Yeah.
This is the only thing she mentioned. So, boy, this is it's a surprise. It came out of nowhere.
Yeah.
And we never would have found it if it wasn't for the fact that we have another judge there looking at stuff. Otherwise, no one ever, because did Miss Love ever say anything about it? No.
It's crazy.
Did Miss Holt ever say anything about it? No. They didn't say a word.
Especially when they know all the rigmarole and argument that's been made over the first one, to just not even mention this. Like I just got to be honest. I cannot trust a single thing these prosecutors do or say. That is confirmed to me. I can't trust anything unless it's in writing and proven and whatever. I'm not trusting. Imagine being a defense lawyer on this case. You literally can't. And I'll tell you right now, I bet you the judge feels the same way. She's not going to say that, but I bet you the judge is not going to trust her as far as she can throw her.
Let me give you an example where I have come across this kind of thing where prosecutors, I just couldn't trust the thing prosecutors said. And the remedy for that is, and I've done this, I've told prosecutors I won't talk to them unless there's a court reporter present. That I won't talk to them on the phone. I won't do anything. But if they want to meet and talk to me, that's fine. But there's a court reporter going to be there so that every word they say is taken down, because I don't trust them. And I've done that. I mean, as laborious as you think about it, you have to get a court reporter every time you talk to a prosecutor. But it just got to the point where I had to.
Yeah, I get it. And then you're protected on your side, at least.
Right.
All right. Well, hopefully you guys enjoyed that one. That was a little bit more. I thought it was kind of going to be more of a nothing burger, but that was pretty interesting. That was pretty bad. So that's all we got for this one. Until next time, we're out of here. Hit the like button, subscribe, do all the YouTubey things. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a page you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.